Good Tuesday evening. I'm Joe Gillaway, welcoming you to This and That, the podcast, where we hope to bring you guests and topics you'll find educational, captivating, and fun from the worlds of pop culture, arts and leisure, local government, and beyond. This and That, the podcast is brought to you by, let's get our This and That, the podcast sponsors up there, Team Pennsylvania, AAU Basketball, Rickabaz Electric, the American Legion, Post 272, right off of on North Mountain Road, right off of Route 81, and Linglestown Gazette Sports. Thanks to these great local businesses for their continued support of This and That, the podcast. We really appreciate it. Upcoming on This and That, the podcast, a week from tonight, we have, drum roll please. Did you guys understand that? Drum roll with the Martini Brothers, local band Martini Brothers. Wonderful guys, wonderful men, great musicians, and just super entertaining. They've been around for safely, I could say, decades, together as a band. And I believe it's just been the same three of them for a long time. I've known Deuce Gibb, the fellow on the left there, I believe since he's been in first grade or kindergarten, from Southside Elementary, and just a really bright guy and a fun guy. And so I can't wait to have the Martini Brothers on next week. In fact, we're going to do this at a remote location from Dale's Drum Shop in Colonial Park, Lower Paxton Township, Colonial Park. We're all going to get together in the same room and do that one. So looking forward to having the Martini Brothers on the show. Also, I am sourcing another show on addiction and recovery from drugs and alcohol. Who doesn't know somebody that's been touched or plagued or affected negatively by someone in having a drug or alcohol addiction or addiction of some sort? And we're going to have some friends of mine on who are in recovery, and we're going to talk about their active addiction, how they got sober, what it's like now that they are sober. And so we're sourcing the guests at this time, and we'll get a date out and probably do this in the next 2 or 3 weeks. So, and how about our disclaimer? The views and opinions expressed on This and That, the podcast, are those of the participants who voice them and do not necessarily reflect the positions held by This and That, the podcast, as an entity, the sponsors who support the show, or myself. And tonight on episode number 47, that's right, 47. We've been doing this since April of 2025, and we're already on our 47th episode. We'll examine arguably the most contentious and disputable of our Constitution's 27 amendments, written and proposed at a time when those who crafted it had no understanding of how it would someday take on an entirely different meaning and purpose. The Second Amendment is used to protect lives, but has also inarguably been responsible for allowing the lives of countless innocent Americans to be lost at the hands of gun violence. There is two clear sides of this, a line drawn in the sand, many would say. So we'll look at the issue from multiple perspectives and address how well or how accurately it is held up in the 237 years since its adoption. And to help us dissect and make sense of all this, let's bring in our guests. We have Mr. Wayne Heckard. How are you, Wayne?
Just fine, thank you. Thanks for having me on.
Thank you for joining us. And Mr. Joe Sobel. And Wayne is a retired Dauphin County, it was called Votech back then, it's called DC Tech now, principal, but also a gunsmith, a gun enthusiast, a gun historian. You buy and you sell guns. Lots of guns in your life, Wayne?
Yeah, there's rarely a day goes by that I don't have one in my hands.
I kind of figured that. And Joe Sobel is a longtime attorney who has held positions in both the executive and legislative branches of government. So, gentlemen, welcome to both of you. We really appreciate you joining us here tonight. I did some homework, as I always do, but I'm relying on you guys to provide the bulk of the facts, or at least the facts as you see them. And again, we are here to talk about the Second Amendment. So let's take a look at that puppy. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. And that, folks, means that Americans should have the right, or will have the right, under a lot of circumstances, not all circumstances, but to protect themselves with guns. Is that, in a nutshell, what it means, Joe?
I would agree with that.
Okay. I'm just kind of trying to nutshell it here, and then we'll get more into what's behind it and where we're at today with it. But and to be clear, I own guns. Okay. I want the viewers to know this. I am not anti-gun. I'm pro-gun for myself and under the right circumstances and for the right reasons. And I'm pro-gun for all law-abiding Americans who feel the need to protect themselves. I believe they should have that right. So let's just get started and kind of break down what the design was for the Second Amendment. And James Madison was kind of behind this, guys. At the beginning, it was part of the Federalist, number 46 of the Federalist Papers. And I'm going to put this up here. Viewers, please bear with us. We just want to kind of try to hit the ground running with some facts, some information. James Madison was the most influential framer. In Federalist number 46, Madison wrote how a federal army could be kept in check by a militia. A standing army would be opposed by a militia army, basically. And he argued that the state governments would be able to repel the danger of a federal army. Essentially, that's what that says. So, fellas, let's just start with this. Wayne, I'll bring you in. How well has this held up? I mean, here's my feelings on this. It was probably done for the right reasons, okay? But in today's society, if the three of us are upset about the way our government's running things, and we go out and we get 100 of our best friends, we all have guns, or 1,000 or 10,000 of our best friends, do we have the right to go after the federal government? Do we have the right to attack the government because we don't like the way they're functioning? Wayne?
Well, the way you present the issue is provocative toward the notion of a rebellion or something of that nature. And to be quite frank with you, from a philosopher's viewpoint and from a historian's viewpoint, we are at a far, far different time than they were at that time.
237 years, just to be clear.
Think about it. They had just defeated the Redcoats and thrown them out of the country and established a constitutional republic, which Benjamin Franklin said we're fortunate if we can keep it. Okay, the thing is, they feared a national army. That's why one of the minor amendments that nobody talks about is the quartering of soldiers in your house, because the Redcoats at that time come over and take over your farm, take over your place. And so they were very concerned about that. So my concern is, going back to the time that I was an English teacher, I don't know if you want to pull that up or if you can read that there, but if you look, I'll read it. A well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms, should not be infringed. And I have to say this, that just this month, actually, I rephrase that, last month, in April of this year, 2026, the League of Women Voters out in Ohio put an article up on the internet, which you can pull up, and it's entitled "The Most Controversial Commas in the American History." And they're talking about those commas in the Second Amendment.
So explain to me and explain to the viewers the significance of the commas. I think I understand what you're getting at.
And Joe Sobel, attorney Joe Sobel, if I'm not mistaken, was also an English major, so he knows all about this. He probably can diagram the sentence faster than I can. But the thing is, if you look at that, a well-regulated militia, that's not a clause. That's a phrase. There's an article, two modifiers, and a noun. It's like me walking into the room now and saying, a well-baked pie, period. In other words, everybody would be hanging. What's he talking about? Then we go on to, in order to maintain the free state, comma, that's a subordinate clause. Then we get to the basis of it, where there's a noun and a verb, the right of the people to keep and bear arms, comma, shall not be infringed. Joe, we don't write that way anymore.
Right.
Punctuate that way anymore. We don't capitalize that way anymore. As a matter of fact, we don't talk that way.
You can look in newspapers, and the best
Anymore.
journalists in the country and the world 50 years ago wrote entirely, not entirely, but wrote differently than we do today.
One of the biggest, as an English teacher, one of the biggest bugaboos was unnecessarily separating a subject from its verb with a comma.
So
and that is exact. Now, this is nothing new. And I have to compliment you on having this discussion on your podcast, because this is a 21st century issue.
absolutely.
This is when it really exploded, okay? The Heller decision, DC versus Heller, was 2008. And the thing is, since then, this has become a major issue, one of the major issues in the Constitution of the United States. And now you're beginning to understand why, because the language is cryptic by modern terms, okay? The Heller decision, which was Anton Scalia wrote the major decision on that.
Scalia.
Nate, he allowed with that decision, and we used to joke, everybody has an opinion, but the only ones that count are the 9 people that sit on the Supreme Court, because
Right.
we all have an opinion, but if
Right.
we don't follow theirs, we go to jail. But I think that the decision that he made was probably, looking at the language, the right one. By the same token, I would say that the first 4 words can't be disregarded.
Right. And let me bring Joe in here.
A well-regulated.
Right. Exactly. And that's important. We'll get to that.
Right now, things aren't that well regulated.
Joe, thank you for joining us tonight. Does this amendment hold up, at least the way that it was, the verbiage and the way it was written after 237 years? Is it open for interpretation? I believe the answer has to be yes to that, but I want to get your opinion, at least in terms of precisely what the goal was. I mean, is the goal the same now as it was 237 years ago? And how have things evolved since its adoption? How would those who contributed to crafting it back then, how would they feel about it today, do you think?
Well, first, a disclaimer. I'm not a constitutional scholar, nor am I an historian, but I have practiced law for a good long time. Okay. And I'm going to try to give you a pragmatic lawyer's approach.
Okay.
First of all, I'm going to start at the opposite end of the tunnel. I'm going to start at the present, looking at what comprises the state militias today, and that would be the National Guard. And if you look at what has happened with the National Guard since it was nationalized in World War II because of national emergency, that trend has continued. Presidents since then have nationalized National Guard units numerous times for various purposes, most of which might not have been true national emergencies at the scale of World War II. So the state militias, while still technically under the control of the governor, that is, as National Guard, can easily and frequently be nationalized for various purposes. So right away, you have a muddying of the waters. They are no longer completely free and independent as they were at the time of the drafting of the Bill of Rights. At that time, the states had barely formed a cohesive union. They had just drafted the Constitution and very shortly after adopted the Bill of Rights. And they were very much separate legal entities, sovereign states, as they still refer to them. So the context is entirely different.
Correct.
But if you look at the literal language, the references to a free state. Now, today, we have a Secretary of State, and we think in terms of the state as the state of the union. It's a national entity in some contexts. That's not what they were talking about at all. They were talking about the 13 sovereign states as separate, discrete political entities. And they wanted each state to have what amounts to an army. Now, the other thing to think about is, in those days, there were no local police. There might have been a local constable or something of that nature, but there were no police forces. And there were certainly no state police forces. And what they were concerned about was the British habit of using the King's Army as a police force, which is what they did during the Revolutionary War when they occupied Boston and they occupied Philadelphia. And as Wayne said, they were quartered in the houses of civilians against the will of the owners of the homes. And if you look at the Bill of Rights, it's remarkable how specific they are about correcting actual abuses that had been committed by the British upon them as they perceived it. Now, had this occurred in Britain, people would have had no particular grievance or recourse. But because independence was on the minds of the colonials at that point, these were deemed legitimate grievances, as were various taxes and other things we're not going to talk about. So that pretty much sets the context. And within that context, if you read all 154 pages of the Heller decision and dissent, which I just did in preparation for this exercise.
Wow. I didn't expect all that, Joe.
I didn't realize there was that much commentary either.
Wayne, you're slacking, Wayne, just so you know.
They took a deep dive. And what I see as a practicing lawyer is two legal minds, Scalia and Breyer, going at it hammer and tongs to see who was the smarter guy. So you can eliminate about 100 pages of that stuff as just a lot of posturing,
right?
To see who had a better grasp of history and who could cite more ancient statutes. But what it comes down to is, there was a saying that most of us who went to law school heard, which is that hard facts make hard law. And the Heller decision is particularly interesting because it was a more or less ideal set of facts for Justice Scalia to attack. Why? Well, first of all, you have to look at who Heller himself was. He was a special policeman in Washington, D.C. He presumably had firearms training. He explicitly carried a sidearm every day at work. He was a museum guard or some kind of building guard, and he carried a sidearm. So he's the ideal plaintiff to overturn a local set of ordinances that, in the view of Justice Scalia, effectively prohibited him from having a loaded firearm in his home, which is all he wanted to do. That was the issue.
Wow.
He didn't want to carry either open or concealed. He just wanted to have a loaded piece in his home to repel we don't know who.
Right.
So the question is, in an urban setting, what's the history? What's the need? Now, I grew up outside Philadelphia, and I remember on a number of occasions driving past the old armory. Well, what was the armory? It was the place where the weapons used by the militia were stored.
Stored.
And they would go there and they would periodically drill. And historically, that's what it was. And so people, unlike on the frontiers, did not have hunting pieces in their homes. They didn't need to hunt. They didn't need to repel raiders. They didn't need to repel bandits who were roving the countryside. And so they didn't. In the cities, they didn't. And again, the militia relied upon the armories as far as I could ascertain.
Let's
So I'm going to stop
talking.
here.
No. I want to throw this up. You can keep talking.
Yeah.
If anybody wonders, what are we talking about with the militia? There was a number of definitions. The one that we're talking about, a private group of armed individuals that operates as a paramilitary force and is typically motivated by political or religious ideology. Is that correct, Joe? I wanted to throw that up there.
In the modern, very recent context, it is. I don't think they existed at the time of the founding or the time of the draft.
So it wasn't political ideology back then, or
I doubt it very seriously. I think if you look at
I
the
agree
Second
with Joe.
Amendment,
It was for defense of the local areas.
specifically state.
against the government, though.
Well, wait a
It
minute.
could be if it was an intrusive
First of all,
federal government.
this government,
Yes.
the militia was under the control of the governor of the state. And if you read the
States.
Second Amendment literally, it talks about a free state. And so, and again, coupling that with the James Madison Federalist paper, it was clear that the concern was a national army, which would function as a national police force.
So we are pulled away from that notion and that reasoning for adding the Second Amendment by a long shot. Is that safe to say?
It would look that way.
Yeah, I mean,
May I interject?
Yes, Wayne, go ahead, bring it in.
I agree with Joe 100% on this. The thing is, compared to what things were like in those days, that's basically the way that I think that they believe things should be. And I go back to the Heller decision now. I'm not what you would call an originalist per se, but I think the decision was appropriate for reasons that Joe said. This was a cop who carried a gun, and he said, I should have the same right in my home, not to gallivant around the streets after hours with a sidearm, but to have one in my home. I'm a policeman. I'm a target.
Right.
You know, and all of these decisions, the Heller decision, and then Joe knows another big one then shortly thereafter is McDonald versus the city of Chicago, where they exercise the use of the 14th Amendment to support under the Equal Protection Clause. They reinforced the Heller decision with the 14th Amendment, okay, a couple years later. And he can give you the details on that too, I'm sure. But the thing is, the whole idea that an individual has the right to protect himself in the home.
Now, how does the 14th Amendment, which was the right to citizenship and
It's the
naturalization?
Equal Protection Clause.
Okay, all right.
Yeah, the 14th Amendment.
The 14th Amendment is very curious because it includes things like race, Loving versus the state of Virginia, which is I was in high school, and that was black and white people to get married to each other in the state of Virginia. This is in our lifetime.
Right.
And we can go voting rights. We had a situation last week where there's an issue now with redistricting, which may become a 14th Amendment issue. But the thing is, in the 21st century, there is very, very little doubt that very little under the present administration is going to change. And these are the things that we are dealing with today. You know, it's not a matter of opinion of whether I think it's right or wrong or anybody else. The fact of the matter is, we are a nation of laws, which they also teach you in law school, you know, and these are the laws that we're dealing with today. And the other thing I would mention is all of these big decisions were settled on a 5-4 vote.
That's interesting.
Okay.
That's very
So the controversy tonight is very, very much a paramount issue within the United States of America and the political spectrum.
Okay, so let's do this. Let's show. And I mean, the three of us, of course, know this, and I would say 100 out of 100 of our viewers would know this. But let's look at the difference between the guns of that era. We're talking about late 1700s. They were crude and inaccurate, except from short distances. Now, they were great for their day. I'm not insulting the makers of the guns or anything. They shot a single lead ball, which took 15 to 30 seconds to load. They were only accurate from about 15 to 30 yards. Guns that can be owned legally today can hold between 50 and 100 rounds, up to 100 rounds, fire up to 6,000 rounds per minute. There's one gun, an M134, that's capable of that. Hit targets accurately up to 600 yards and can be reloaded in between 1.5 seconds to 3 seconds. So there's what we had at the time that the Second Amendment was crafted. And kind of these are the two that get most of the talk today, guys. M16 and AK-47. And you know, they're not the only guns out there, but I think for the sake of discussing how far we've come, they're probably the two to show. Joe, do you agree? Like, because they're kind of in the news the most, they have caused a lot of loss, a lot of deaths, and over the past couple of decades, especially. But you know, how can there be no changes to this amendment or to the verbiage or the way that it was crafted when there's been so many changes to the guns that are being referred to, Joe?
Well, interestingly, the Heller decision was, in a sense, quite limited. And we've talked about who Heller was and what his purposes were. And the amount of agreement between what Justices Scalia and Breyer, in their respective opinion and dissent, laid out is pretty remarkable. They agreed about most things. And the Heller decision, in particular, cited a number of cases in which it was pretty well settled that what they would call dangerous and unusual weapons were subject to regulation historically, going all the way back. In both opinions were replete with references to that. And so Justice Scalia had no problem at all with the regulation of the very tight regulation of machine pistols or machine guns.
So we, we have become, and I have to mention this, this is part of it. It's not part of the Second Amendment itself, but it's part of what has resulted or what is happening as the result of things not being changed at all. We've become the most violent non-third world country in the world, on Earth. And I only say that because just to kind of segue, can staunch Second Amendment defenders lose sight of the kind of the tragic side of this issue, the lost lives, the hundreds of mass shootings in America each year, the hundreds of thousands of guns that are possessed illegally in this country? Do they go to bat so staunchly for the Second Amendment itself that none of that means anything to them, to a lot of them? Wayne?
There is a small percentage of people out there that are hard right, no change, no compromise. Don't take your finger out of the dike or you'll lose all your
right.
Heard all of this, okay, and we'll probably hear some later on when we have commentary. That's fine. That's people's opinions. But the thing is, I have to look at it and say, both sides, the left and the right on this, in order to reach a solution for the catastrophe that we're in now, and we do have a national problem, we're a national embarrassment. We're worse than any other country, both in raw numbers and in percentage of people per 100,000 killed with firearms. We have a special problem. I honestly do believe on the bright side that the solutions are available, but I think it's going to require compromise on both. I am happy that we have a Second Amendment. I exercise my Second Amendment
We
right
all three here do. Just
every
to
day.
be clear, yeah.
Okay. But I keep coming back to, I think to answer your question a couple moments ago was, what do you think the founding fathers had in mind? No, they were very intelligent people, and they created a very viable, strong document. And they also presented a way to change it. It's hard to change it. You have to have 2/3 vote in both the House and the Senate to make an amendment or to change an amendment, and that was done for a purpose too. So there are legitimate ways that things can be done. After that, we also have regulations, bureaucratic regulations, and local, state, and local ordinances. One of the interesting things that I see right now is, again, a couple of years ago, there was it went to the Supreme Court, the New York State Rifle and Pistol Association versus Bruin. Here again, the question was, does a state like New York have the right to tell people they can't carry a gun? The decision of the Supreme Court was, no, they can't. However, it does not abrogate any existing laws or the historical background of what brought us to this point. Well, New York City has the Sullivan Law ever since 1901, for over 100 years. If you walk down the street and brandish a handgun in Manhattan, you're going to end up in the jail. Okay, you're going to go to Rikers Island. And the thing is, to this very day, even though the Supreme Court said that they don't have a right to do that, a place like New York City is still allowed to do that because they are a, quote, dense urban area, and that is a historical precedent for 110 years.
Well, I agree with that to a degree, but I'm sure we all remember Bernard Goetz, right? He brandished and used a handgun on a New York City subway, and he was found not guilty because he got. And all I'm saying is, if you get the right jury, which he did, was either found not guilty or maybe, I don't know if he pled to a lesser charge. Joe, you would know that. I think he was found not guilty. But the law does say that if you're in New York City, you're not supposed to have a gun.
Yeah, but in New York State, and Joe can explain this too, I think there's 4 states and the District of Columbia, a minority, are what we call may issue states.
Illinois.
If you go to your county sheriff and ask to have a carry permit, they may issue it based on whether they like you or not.
Right.
The other majority of states, including Pennsylvania, are shall issue states. If you go in and you're not mentally adjudicated, or you're not a felon and you're normally a decent guy, the onus of burden on them is on them if they deny you a permit. So we call it a shall issue state. You'll get your
Okay. All right.
Okay. So
let me
incidentally, the licensed people, the people that carry a firearm with a license, the sheriff will be the first person to tell you they're not the problem. They're part of the solution.
So these gun laws,
guys that don't have a permit.
Right. Absolutely. And that's kind of what the path I want to go down now here. And I'll bring Joe in for this. Another thing that I believe has evolved in this country is we're more addicted than we ever were to drugs, to alcohol. The level of mental illness is greater than it's ever been. And I mean, I guess, if somebody said, well, prove it, I'd have to, I probably could, but off the top of my head, I can't. You can't legally drink. You can't legally enter a casino, rent a car, rent a motel room, work at certain jobs or in certain fields until you're 21 to 25. But in some states, you can buy a long gun when you're 18. I think a lot of states.
We can.
Are we not keeping up, Joe? You're kind of approaching things not from the legal aspect of that you do this for a living, cover, the age of consent for guns and stuff. But do you think that Americans are getting kind of maybe more addicted, more irresponsible and whatnot, and the laws aren't being changed to deal with that aspect, Joe?
I'm not convinced that laws are the answer to every problem. But first, I just want to add something to what Wayne said about the 14th Amendment and the references to various ways in which it has been used other than in relation to firearms. The 14th Amendment is the catalyst that enables application of constitutional principles to the individual states. Because if you read the Bill of Rights, it refers all the time to Congress. And in order to apply those principles to the states, they've used the 14th Amendment in numerous instances. So moving on from there, the difficulty, again, is that laws don't necessarily solve problems. At times, they can create new problems.
That's a great point.
The first issue with any law is a question of interpretation. The second is the question of enforcement in no particular order. Law is meaningless unless it is enforced even-handedly and properly. And that gets us back to, again, one of the issues in the Bill of Rights, the Second Amendment. It refers to the right of the people. Now, interestingly, there is no clear definition of who the people are in the Heller decision or any other. There is the inference, going back, doing some research on their part, that the people are, first of all, they mention the voters. The people could be the voters. The people could be the people who inhabit the continent on the other end of the spectrum. So the question is, who exactly were the people that the Second Amendment, the First Amendment, the other references to the people in the Bill of Rights? Who were they? Now, in 1791, African Americans were not people, so it didn't apply to them at all.
Mm-hmm. Right.
And only white men who owned property essentially had the vote. So
they were probably the people, Joe.
So they were probably the people.
Yeah.
Now, ironically, as a core part of his argument, Justice Scalia says, well, the people are, after all, the people. They're all the people, not just the militia. You can't single out a segment of the population and say it applies only to them. But if he's an originalist, he's got to take into account that the people in 1791 were only the white guys with property.
White people over age 18.
Right.
Yeah. I mean, and just to pick up on something Joe just mentioned, this does not appear anywhere in the literature, but it has been repeatedly by the anthropologists and historians said that it was always an underlying motive. One of the reasons, one of the main foci of the militia in the southern states would have been to subdue a slave revolt.
I think that's historically accurate.
It would have to be. When you're talking about that era of our country, it would have to be. That was a big issue.
Right.
And
it was a big issue for the people with the most power, but let's put it that way.
Yeah. And as
write these things. ahead,
as
Joe.
the Heller opinion and dissent both reflect, the earliest recorded form of firearm regulation was a series of statutes in the major slaveholding states that prohibited Black Americans from owning firearms,
Yeah.
even after the Civil War.
Right.
That's the
That's-
first thing they did.
Yeah, that's rough. I don't
Something
know.
that might be germane to our issue, it's tangential to our issue, is what some of the other countries are doing and have done. And certain ones come to mind. I try to make it very quick. There's only 2 other countries in the whole world that have a written constitutional amendment to allow to keep and bear arms. There were several others. Some of the other ones were Czechoslovakia and Serbia. They withdrew the language over the last 20 years, but 3 remain: the United States, Mexico, and Guatemala. You have a right to keep and bear arms, but you wouldn't know it by American standards. In Mexico, there is 1 gun shop in the entire country, and it is on a military reservation in Mexico City. You have to travel to Mexico City and get approval to get onto a military reservation to exercise your, quote, constitutional right to keep and bear arms.
So it's not going to be easy for the wrong
They
people.
sell 15 to 20 a day.
Yeah.
But 85 to 100 go across the border from the United States and go into the black market.
Right.
So it's not, even though they have a constitutional right, it's not what we would call a right. Guatemala, to make a long story short, is worse. All right. Now, we think, oh, Russians can't have guns. Nothing could be further from the truth. It's true. The average Russian cannot have a handgun. But at age 18, if he's a good boy or girl, he can go into his local police station and get a permit to buy a shotgun. It's a massive country. They hunt the meat.
Yeah.
It's a big deal, and at age 21, if you've been a good boy or girl with your shotgun for 3 years, you can apply to buy a rifle. It'll be approved. Then what they do is shoot 2 rounds through that rifle. One goes to the central agency in Moscow, and the other spent bullet, goes to your local authority.
So they can record it like a thumbprint or a fingerprint.
You are responsible for that gun.
Right.
Okay. They're an armed country. They don't have the problems. You go to a place like Switzerland, it's automatic training for everybody to learn how to use a rifle. They have a civil guard in that country. Moreover, the Swiss are all mostly blue-eyed and have blonde hair, and they're white people. They're a very homogeneous group. Okay, but there are other places in the world where they have guns, but they're not killing each other left and right.
Right. So I guess where I was going, Joe, and I love your response. That I'm not convinced that laws and changing laws is always the answer. But when I was talking about, some of the people that we put guns into their hands legally, I think more of what I was trying to get at is, are the background checks sufficient? What about straw purchases and gun show purchases? And maybe that's for another show, but we can kind of just talk briefly about, straw purchases. I can't get a gun because I'm a convicted felon. So Wayne, or I shouldn't use Wayne, but a friend of mine who's not a convicted felon goes into a gun show, buys the gun, walks out in the parking lot, hands it off to me. I mean, that's a big no-no. But it seems like that's kind of common. A gun show purchase, I refer to a gun show purchase as something that this dealer might have just loads of people around his stand for hours and hours and hours a day for 2 or 3 days. He might not be going through all the proper legal, let me just say this. It's a lot harder to scrutinize a buyer when you're just packed and you're on your own there. And then the last thing was background checks. Should there be cool down periods? Or should we just say, hey, the guy's legal. Let's let him leave today. I know I just said a lot there and I kind of babbled it out, but that's the gist of what I wanted to address. Either one of you want to take that, like the path and the route we take to get guns legally, and is it working? Is it sufficient? Wayne,
You want to start, Joe?
Oh, Joe, go ahead.
Well, yes, in the sense that a lot of what we're talking about now relates to enforcement. Do we want to have an ATF agent standing at every exhibitor table at a gun show to watch what's going on?
No.
And I would go. I go to a gun show. I'll be going to one this Friday in Allentown. It's quite uncommon for a dealer to sell a gun at a gun show without following the rules, and 100%.
So when we see these cases, they're rare. Is that
Well,
what you're
they
saying?
know that the ATF is
Okay.
there. As a matter of fact, usually on setup time on Friday nights, the people who run the show will get on the PA and say, ladies and gentlemen, just a word of caution. If you think the ATF is not here, you better think again. Because
Okay.
they're all ready, and they'll be here Saturday and Sunday too.
All right.
And the thing is, nobody wants to lose their license because of a phony deal, okay, for a few bucks. They don't.
So we feel good about the laws and that they're being properly enforced.
If
by and
they're
large.
enforced, the one thing I don't like the interpretation of certain laws, and I don't like what's happening with the modern technology. Okay, and I will say, and I think Joe Sobel will agree with me, the laws do have to keep up to some certain degree with the technology, and I don't think it has. Okay, let me give you an example. I went into a gun show, hit and run, spent an hour there at Morgantown about 2 years ago. And a guy was there selling what they call the ghost guns. Now, a ghost gun is one that they make, and it doesn't have a couple holes drilled in it. All you have to do is go over to your drill press, drill the holes in, and you've got yourself a gun that you can assemble. Okay? They're able to sell them without paperwork, without licensing, and at a reasonable price. This is Morgantown, about 25, 30 miles outside of Philadelphia City. Guy walked in and said, hey, how much do you want for that ghost gun? And the guy says, $210. He said, how many of them do you have? Let me check. He goes under the table. He says, I got a dozen of them. The guy says, I'll take them all. Now, do you mean to tell me that they're not going to end up in Philadelphia?
So he just paid $2,500 for a dozen guns, basically.
I know police down there to tell me that the ghost guns are a major problem. The bad guys can have them. They don't have to pay. They don't have to go through the licensing. Every time somebody sells a gun, a ghost gun, it's an affront to someone like me who has a federal firearms license, and I record every.
Right.
You know, and the thing is that there should be controls on stuff like that, because we all know where the stuff's going. It gives the rest of us a bad name.
So let's go down. Let's kind of wind down this path. And Wayne, I know that you wanted to. I had this question written before I knew that you had an answer prepared for it. What would be, Wayne and Joe, the ideal 21st century interpretation of the Second Amendment, or how should it or could it be written now to apply to all the changes that have been made in guns, all the changes that have been made in our population, and that we don't really have these militias running around and we're not meeting in back rooms at people's homes, all the things that we just discussed for the last 50 minutes, all the changes. Where should we be now with this Second Amendment? I think we all decided, just from what we've all talked about, that we're in support of the Second Amendment. I don't know if Joe owns guns or not, but I know that Wayne and I both do. And I'm only saying that so that the people that are watching don't think that we're just some snowflakes that, you know, we would just want guns out of everybody's hands, because we're not. But where do we stand now? And I'm going to start with Joe. Or where do things stand now as far as how do you think that the Second Amendment, kind of in layman's terms, should be written to defend an American's right to bear arms in 2026, Joe?
Actually, I wouldn't do much to change it. I would, I think, update the language somewhat to place it in a modern context. For example, the word that troubles me most in the Second Amendment is the word infringed. And if you read Heller and you read it very carefully, they make no effort at all to define the word because they don't know what it means. Now, I mean, that troubles me. And the best I can ascertain, it really is supposed to mean unduly restricted.
Mm-hmm.
You can regulate it in a way that makes sense in the time and place. I do honestly believe that the founders were forward thinking, and they were trying to come up with a document that would be subject to proper and timely interpretation in the future.
These were the best we had back then. Our founders. Just so you know, I don't want anybody to think that I think that they were archaic and behind the times and really not.
No, the Constitution is a good instrument.
Absolutely, yeah. They were gems. They were American gems and bright and forethinking. And go ahead, Joe.
So I wouldn't presume to tamper with it. I'm going to make reference to an interesting piece of technology that I learned about touring the Brandywine battlefield some years back. Apparently, there was a Scotsman who was a British officer named Ferguson, Patrick Ferguson, who invented the first widely available repeating rifle. It was very expensive to manufacture. The British had, thankfully, very few of them, or they could have driven the colonials off the battlefield.
Semi-automatic, would that be? Would that be a semi-automatic back then?
More like a carbine. It was simply a repeater.
Okay.
And Wayne, you'll be familiar with that. I was surprised and I was impressed. The point I'm making is it existed at the time of the Battle of Brandywine, where Ferguson was present and was employing it in his company of British regulars. And it was very effective. And so they were aware at the time, or should have been aware, that technology was on the march, even in 1777. Yeah. So they were taking that into account, and that is why you find the statutory language concerning the interpretation, which refers to unduly dangerous or unusual weapons. They were thinking in terms of what a militiaman would carry as part of a well-regulated militia at the time. Now, if you carry that forward, you'd be looking at what the National Guard issues to its infantry. And so it's certainly going to be an updated firearm and is going to be capable of firing many more rounds. The question now is whether that should appropriately be the standard. If the National Guard has issued M16s, should you be able to walk into your neighborhood gun store and buy an M16? Well, the answer has turned out to be, well, maybe you can, but it can't be full automatic. And so we've reached a point where there seems to be a common sense, intuitive response to that. And as Wayne pointed out at the top of this discussion, actually, very few of those are used in street crimes in this country or even gang-related violence in this country. Now
You're
that
talking
gets
about AK-47s or
To me,
M16s, right?
to me, a semi-automatic is an analog. I can operate a semi-automatic almost as fast as I can operate a full automatic.
Right. Yeah.
And with
and that
some
would
of
be a
these,
well-regulated militia because you've had the training to do that.
Right.
right, and right. But I would agree with Joe on the notion that I wouldn't fiddle with anything at the constitutional level, at the amendment level. I would allow it much more, and I think Joe would agree with this, much more under the 10th Amendment, under the Reserve Powers Clause, to leave it up to the states to determine. Have the Second Amendment as it stands, take the comma out if you want, make a little more sense out of the thing, subject and verb together. But the fact of the matter is, let it go, let Scalia's decision go, and then let it up to the states to determine how they're going to interpret and regulate that situation. For instance, if you tell somebody in the state of Wyoming that they can't have a gun, they're going to look at you and laugh.
A lot of states like that.
All right.
A lot.
There are more people in Nassau County on Long Island by many than there are in the whole state of Wyoming. And in Wyoming, if you call a policeman, if they decide to show up, it's going to be an hour. Okay. However, in a place like Nassau County, where you're up shoulder to shoulder with everybody else, and you have a very diverse population, you're going to have a lot of crazy people because there's a lot of people to start with. Their view is going to be entirely different. And their laws and rules, regulations, and mores are going to be different to reflect those things.
Fabulous point.
So that's why I think states' rights is part of the answer here.
Well, I will agree with that with one exception, and that is that I agree with Wayne's observations concerning so-called ghost guns. I think we need a national definition of firearm that deals with that problem.
Yeah. It doesn't seem like there would be a sound argument against what you just said, Joe. I mean, I'm sure somebody would find one or concoct one, but yeah, that's dangerous when somebody can walk in and with $2,500 and leave with 12 guns and just a box of guns and they're not really.
And it's a problem 25 miles away,
and they're not treated the same way as actual guns. Is what is kind of the end of that comment, but. Anything else, guys? You guys want to close with anything? I that's what I had to close with, but it's, you're the guest. It's your show here tonight. And
I'm very happy. Joe, do you have anything to say?
No, I think we've covered the spectrum pretty well.
Kind of three moderate, middle of the road, Second Amendment defending men. It seems like to me. I didn't know what to expect, and you guys will. Well,
as I say, I repeat myself. I think answers can be had. People that tell you that laws don't make any difference at all. Joe's right. They don't guarantee anything.
Right. Absolutely.
We're still going to be bad people.
Right. Yep.
But the thing is, we're a nation of laws. 1934, we started with the National Firearms Act. That's what gives us that one shot per trigger pull law. And in 1968, after all the assassinations, we reacted with the Gun Control Act. We have all kinds of laws. Laws were extant even in the Wild West. If you pulled into some towns like Dodge City, you did have to hang up your pistol in the sheriff's office and pick it up when you left. They didn't want guys going down to the casino in the bar room getting stone drunk and shooting each other.
Right.
We have had common sense rules to keep people safe.
Right.
And we can have guns. And we can enjoy our hobbies and our collecting and our shooting and our hunting, and we can protect our homes. But there can be some controls to mitigate what's going on the crazy side of the country.
Right. Thank you to Wayne Heckert. We really appreciate it. Once again, he is a retired school principal at Dauphin County Votech, now known as DC Tech. But more important for this conversation, Wayne is a gunsmith, a gun enthusiast, historian. He buys and sells guns. And so you're a perfect guest for the show tonight. And longtime Harrisburg-based attorney Joe Sobel, who has held positions in both the executive and legislative branches of government. And, you know, I didn't know what to expect tonight. We can tell the viewers, you know, with all candidness that we don't prepare this stuff. And we just kind of wing it. You know, we chat for a couple of minutes before we go on the air. And I just really appreciate it. I chose the right two guys for this conversation. And
well, thanks for having us.
Yeah. If we ever
thank
do
you very
anything
much.
along these lines again, or even other lines, you guys are two bright guys, and you were great guests, and I really appreciate it. So let's thank our sponsors once again: Team PA, AAU Basketball, Rickabaz Electric, the Robert H. Hoke American Legion Post 272, and Linglestown Gazette Sports. Thank you once again to these great local businesses for their continued support of this and that, the podcast. So for Wayne Heckert, Joe Sobel, I'm Joe Gillaway. And thank you for tuning in tonight. We really appreciate it, everybody.